You are watching State Law Exposed, the show that reads the statutes, finds the cases, and tells you exactly what New York law says in plain language. Not what an insurance adjuster told you. Not what a property manager rehearsed. Not what a dog owner looked up on his phone the morning after the attack. What the law actually says. This is episode 4. 3 cases, 3 New York laws, and 3 outcomes the other side never intended you to find out about. Story 1 starts right now. 3 people, 3 different boroughs, 3 different traps to system leg for them. A nursing assistant was hit by a driver with no insurance, and her own insurance company waved a piece of paper claiming she had signed away her rights. A daughter watched a clock tick toward the day it would be too late to hold the hospital responsible for her father's death. A postal worker was mauled by a dog while doing his job, and the owner's lawyer cited a legal doctrine that New York abolished 15 years ago. All 3 were told the door was closed. All 3 found a window, and all 3 walked away with something the other side never intended them to have: justice and a check. Stay until story 3, because what New York did to the one-bite rule is one of the most quietly radical changes in personal injury law in the last 2 decades. Simone Baptiste was 29 years old, a nursing assistant on Staten Island, double shifts, overnight rotations, the kind of work that pays just enough if nothing goes wrong. On a clear January afternoon in 2026, nothing went right. She was sitting at a red light on Richmond Avenue when a car behind her hit her hard. The impact snapped her neck forward. By the time she got out to check the damage, the other driver was already running. Police found him 3 days later. Suspended license, no insurance, no meaningful assets. Simone had a herniated disc at C5-C6, $38,000 in medical bills, 6 weeks off work, and a physical therapist telling her she might need surgery. Her own insurer delivered the news in a single sentence. She had declined uninsured motorist coverage at the time of purchase. She had apparently signed a waiver. Simone had no memory of signing anything and no copy of any waiver. But the insurer kept repeating the same phrase with the calm certainty of people who say it to the same kind of person every single day. You waived that coverage. Her medical bills were compounding. Lost wages hit $7,200 and kept climbing. Every 2 weeks, a new physical therapy invoice arrived. The at-fault driver had nothing. The insurer had a piece of paper, and Simone had a feeling that something wasn't right about that waiver. She was correct. She just didn't know it yet. New York Insurance Law Section 3420 phone requires every auto insurer to offer supplementary uninsured, underinsured motorist coverage, some coverage, to every policyholder. That's a mandate, not a courtesy. And any waiver of that coverage must be executed on a specific NYDFS-approved form with a proper acknowledgement section. A defective waiver, wrong form, missing language, missing signature, is not a waiver. It's a piece of paper. But New York went further. It created the Motor Vehicle Accident Indemnification Corporation, MVAIC, under Insurance Law Section 5201, a state-backed fund financed by all licensed insurers that exists specifically to pay victims of uninsured and hit-and-run drivers. MVAIC doesn't care whether a sum waiver was valid. It's an entirely separate recovery path. Most victims never know it exists. Simone had 2 doors. Her insurer had been pretending both were locked. Simone's attorney demanded the waiver. The insurer produced it. It was not on the NYDFS-approved form. The acknowledgement section was missing. The waiver was legally defective, and a defective waiver is a non-waiver. Some coverage at $25,000 was reinstated as a legal requirement, not a favor. Her attorney simultaneously filed an MVAIC claim as an independent path. Combined, $47,500, more than her total actual damages. The waiver her insurer had waved at her like a magic shield had been defective from the day it was written. 2 doors were open from day 1. Her insurer knew about both of them. They were counting on Simone not to. Well, if this is opening your eyes, hit subscribe. New episodes every week. Real New York law, real cases, real money. The next case could be yours. Simone's situation, a clock she didn't know was ticking, is nothing compared to what comes next. Because the woman in story 2 almost lost her chance at justice. Not because she was late, but because no one had ever told her that a clock existed at all. Adise Mosu's father was 67 years old when he checked into a Brooklyn hospital for a routine hip replacement. He did not survive. In the post-operative recovery room, a surgical resident administered an incorrect medication dosage. The error was documented, but grief is not a legal strategy. For the next 2 years, she was consumed by estate management, her mother's care, her own life trying to reform itself around an absence. In early 2026, she finally sat across from a malpractice attorney. His first question was not about the dosage error. It was not about the surgical resident's credentials. What was the exact date of death? The question stopped Adise cold. She felt the trap before she could see it. Her father died September 14, 2023. The attorney did the math out loud. New York CPLR Section $214 and imposes a 2.5-year statute of limitations on medical malpractice claims. The window would close on March 14, 2026. It was now February. 5 weeks. She had 5 weeks. The thought that her father's death might go legally unaddressed. Not because there was no negligence, not because there was no evidence, but because she hadn't known about a 30-month countdown no one had ever mentioned, was the kind of realization that changes how a person sees the entire concept of fairness. New York CPLR Section 214A is the governing statute. 2.5 years from the date of the malpractice, or from the end of continuous treatment by the same provider for the same condition. For wrongful death arising from malpractice, EPTL Section 5 to 4.1 provides a separate 2-year wrongful death limitations period running from the date of death, and it runs parallel and independently. There is an additional layer. The hospital was a New York City Health plus Hospitals facility, a public hospital. Under General Municipal Law Section 50E, a notice of claim against a public entity must be filed within 90 days of the incident. That 90-day clock runs simultaneously with and independently of the malpractice statute. New York medical malpractice law is a system of overlapping clocks running at different speeds. Missing any one of them closes a door that cannot be reopened. Adase's attorney moved immediately. A notice of claim was filed against the NYC Health Plus Hospitals facility. A board-certified anesthesiologist reviewed the records and confirmed. The medication dosage error during post-operative recovery deviated from the accepted standard of care. The case proceeded under both malpractice and wrongful death theories. 22 months of litigation, expert depositions, a complete review of every medical record from the hospitalization, and ultimately, a resolution, $1.85 million, divided between Adaise and her mother as the estate's distributees. Her father did not come home from a routine hip replacement, but the hospital's own documentation told a complete story. The law gave that story somewhere to go. 2 stories down, 1 to go. And story 3 is about a legal doctrine that every dog owner in New York thinks protects them, and hasn't actually been the law here for 15 years. Kendon Park was 31 years old and had been a postal carrier in Flushing, Queens for 6 years. He knew the route, he knew the dogs, he knew which gates to respect. On an April morning in 2026, a German Shepherd came through an unlatched gate, off-leash, no warning. The dog walked onto Kevin's forearm and wrist before he could back away. 40 stitches, nerve damage affecting grip strength. A therapist report confirming PTSD, not the reflexive kind that fades, but the kind that makes a man hesitate before approaching a residential address on his own route. The dog's owner appeared at the door within 2 minutes. His first words were not an apology, they were a legal argument. The dog has never bitten anyone before. You have no case. That's the 1-bite rule. He said it with the confidence of someone who had looked it up. He was wrong. But neither of them knew that yet. The 1-bite rule, the common law doctrine that shields a dog owner until their animal has demonstrated prior vicious propensity through an actual bite, was superseded in New York in 2010. New York Agriculture and Markets Law Section 123 codified a strict liability standard. Once a claimant proves the owner knew or reasonably should have known of the dog's vicious propensity, liability is established. No prior bite required. And vicious propensity in New York does not mean has bitten before. Under Collier v. Zambito and its progeny, it includes growling, lunging, snapping, aggressive barking, fence charging, and breed-specific behavioral history, if the owner was aware of it. The standard is knowledge of dangerous behavior, not knowledge of a prior bite. The dog owner's legal theory hadn't been New York law for 15 years. The insurer citing it was either misinformed or counting on Kevin not to be. Kevin's attorney deposed the neighbors, 3 of the dog owner's immediate neighbors. 2 had watched that dog lunge at pedestrians repeatedly. 1, without being asked, pulled out their phone and showed the attorney footage from their Ring doorbell camera. 2 prior incidents. On camera, the dog charging at postal workers approaching the house. The homeowner's insurers, won by defense, collapsed on deposition day 3. There was no remaining argument that the owner didn't know. Kevin recovered $185,000, $48,000 in medical expenses, $27,000 for future nerve treatment and possible surgery, $45,000 for lost earning capacity, and $65,000 for pain, suffering, and documented PTSD. His workers' compensation claim ran in parallel. The tort recovery was not offset by comp benefits under New York's separate recovery framework. 3 people, 3 different laws. 3 outcomes the other side was certain would never happen. Simone's insurer waved a defective waiver at her for months. New York insurance law says a defective waiver is no waiver at all. An MVAIC exists precisely for the moment when the at-fault driver vanishes and takes all the money with them. Eddie's had 5 weeks left on a 30-month clock she didn't know was ticking. CPLR Section 214A doesn't care about grief. It doesn't care that no one told you. It runs regardless. And getting it in time, barely, but in time, is the difference between $1.85 million and nothing. Kevin was quoted a legal doctrine that New York abolished in 2010. Agriculture and Markets Law Section 123 replaced it, and his neighbor's Ring camera footage proved the owner knew exactly what that dog was capable of. 3 clocks, 3 defenses, 3 outcomes. The system didn't find them. They found the system. That knowledge is yours now, too. That's episode of State Law Exposed. A defective waiver, a 30-month silent clock, a dead legal doctrine a homeowner was still counting on in 2026. 3 laws, 3 wins, every single one of them sitting in the New York statutes right now, available to anyone who knows where to look. That's what this show is for. If this episode changed how you see any of these situations, share it. Send it to someone dealing with any one of these right now. The law doesn't help people who don't know it exists. Hit subscribe. New episode drops every week. Same format, 3 stories, 3 laws, 3 outcomes that surprised everyone except the attorney who knew what the statute actually said. This is State Law Exposed. See you next week.